Hello, everyone. I'm Brandon. I hope you can see me and hear me. Let me know if you can't in the chat box, but I think everything is working. Um, like I was saying, my name is Brandon. I'm an LSAT instructor with LSATMax. I also teach bar exam prep for our bar exam prep service, BarMax. I was a lawyer for a few years. Obviously, I went to law school. I took the LSAT and got a 175 in 2006, many years ago. All right, it looks like everybody's seeing and hearing. That's good. Um, I graduated from UCLA School of Law in 2011, and I practiced law for a few years. So today we're going to talk about argument analysis on the LSAT. At the end of today's presentation, though, I'm going to open it up to questions, and I'm happy to take questions beyond just the topic that we talk about today. That's why I was giving you my background. I'm happy to answer questions on law school applications, what it's like to go to law school, being a lawyer, things like that. So at the end of the presentation, if you have those kinds of questions, feel free to drop them in, and I'll just explain a few different ways that you can participate. Feel free to drop them in the Q&A box. So down at the bottom of your Zoom screen, there's a couple of ways that you can participate in today's presentation, and our presentations always welcome participation. So like I was saying, I'll answer questions in the Q&A box at the end of today's presentation. So if you have questions outside of the subject matter at any particular moment, just feel free to drop those in the Q&A box, and I'll pick them up. There's also a chat box. I will try to keep an eye on it when a presentation gets fairly big, and it looks like we're going to have over 100 attendees. The chat box sometimes starts to go by pretty fast, so I might miss your comment. Katie is also monitoring the chat box, so she will hopefully pick up the things that I miss. But you're welcome to ask questions and comment there. There's also a participants box where you can raise your hand, I can call on you, and then you can talk to everybody just like I'm talking to everyone right now. So those are the ways to participate, and I hope that you will take advantage of some of them. Now let's just do a little bit of housekeeping before we talk about argument analysis, which is hugely important on the LSAT and also hugely important in law school and as a lawyer. But here are just a few things that I want to tell you about before we get started. First of all, starting last year, LSATMax inaugurated our Justice in Action initiative. That's where each year we are selecting, and there's a link for it in the chat box if you'd like to participate. The idea behind the Justice in Action initiative is that each year over a 5-year period, starting in 2020, LSATMax selects 200 students who have demonstrated a commitment to social justice, and we're going to help those students starting from before they start studying for the LSAT. So what happens is if you get selected as one of our Justice in Action participants, you get a free LSATMax LSAT course, you get free law school admissions help, you get our 1L course, which helps demystify the first year of law school, which can be very difficult. You get our 1L course for free. We'll help you find a job as you're in law school, and you'll also get a BarMax bar prep course for free. So all of that stuff is super helpful, and I suggest you have a look at it. The way that the application works is you fill out a couple of essays telling us about yourself, and then we will get back to you very quickly and let you know if you have been selected or have not been selected. But I do think it's a really awesome program. I'm very proud to be a part of it. The last announcement is our podcast, The Legal Level. Please check it out. I host that podcast with Yelena War, who is a very brilliant LSAT instructor. We have an episode that should be dropping any moment now about how to strengthen and weaken arguments. So after you're done here learning how to analyze arguments, you can take the next step there. All right, so that is a whole bunch of announcements. Mariah says, love the podcast. Thank you. I hope it's helpful. And also, and I hope I'm pronouncing this correctly, Ali Kiju says, I'm a beneficiary of the JIA program. Well, welcome. I hope that we are living up to your expectations. So anyway, I am going to share my screen with you. And then we will get started. Oh, that was not what I meant to do. Share content, that's the one. All right, I think you are seeing what I am saying. So let's jump in and talk about acing argument analysis. So what is the big deal with arguments? Why do we care about arguments? Well, lawyers and people who are in law school, their lives revolve around argumentation. So lawyers advocate for people. They represent clients. And one of the main ways that they do that is that they make arguments on their client's behalf, very often in court, very often in front of a judge or a jury. They also, very importantly, represent their client's interests by attacking the arguments of opposing counsel. So if you are leading your client through litigation, you're going to be making arguments that your client is in the right. And opposing counsel is going to be making arguments that his or her client is in the right. But obviously in litigation, it's very much a zero-sum game. So usually you're not both right. In order to represent your client's interest well, you must be very good at constructing your own arguments. You must be very good at attacking other arguments. And so that's why arguments are important and why they're tested. Law school is largely about reading arguments. And when I say reading, I include in that understanding. And that's largely what we're going to focus on today, understanding arguments. They construct their own arguments after learning about other arguments. And then, and like I was talking about, very importantly, they criticize arguments. So we will be talking about criticizing arguments as well a little bit later in today's presentation. That is also very, very important. And the LSAT tests your ability to do all of these things. So where are they in the LSAT? Well, the one place that argumentation does not show up in the LSAT is in logic games. Logic games has no arguments to it. Instead, you are given some rules and a set of facts, and you are required to figure some things out about how those rules and facts interact. So putting logic games to the side, the rest of the LSAT is dominated by arguments. In logical reasoning, the vast majority of questions have at least one argument, and some, including several that we're going to look at today, have more than one argument. And it's important to understand what those arguments are and how they interact with one another. So in logical reasoning, I'd say probably 90% of questions have an argument. There are a couple of common question types that often don't have an argument. Must be true questions often don't have an argument. What we call paradox questions, some other companies call them resolve or explain questions. Those often don't have an argument. But all of the most common question types, errors in reasoning, what some companies call flaw questions, strengthen questions, weaken questions, sufficient and necessary questions, those all contain arguments. And so the vast majority of logical reasoning questions have at least one argument and sometimes more. And it's possibly even more important to understand how argumentation works for reading comprehension because every single reading comp passage contains at least one argument. And most of them have more than one argument. And so again, it's important to be able to pick apart those different arguments and understand how they interact with each other. So if you want to do well on these two sections, which are currently about 2/3 of the exam right now, if we ever go back to a normal LSAT, because logical reasoning counts double on a normal LSAT, these sections will account for about 3/4 of your score, which means argumentation is very, very important. So what is an argument? It's not just where you and your significant other pick something totally trivial to disagree about, and then both of you cry and don't talk to each other for weeks on end. That is not an argument. Arguments you have probably dealt with a lot as an undergraduate already. Probably many of the readings that your professors assigned to you, depending upon what classes you took, were people making arguments. So you already have some understanding of how these things work. But let's break an argument apart into its pieces, because that's going to become incredibly important as we move forward. So arguments always have two parts. Sometimes there's more stuff that is written in the paragraph delivering you the argument, but really the argument boils down to these things. There is a conclusion, and that is the thing the author wants to prove to you. This is the whole point of the argument. The point of the argument is to prove something to you. Everything else is stated in support of that goal. And you can look at the conclusion as the author's goal, or as like the destination the author is trying to reach. There is always at least one premise in an argument, and the relationship between premise and conclusion is what makes an argument an argument. And a premise is just a reason that the author offers for you to believe the conclusion is true. And so the way arguments are supposed to work on the LSAT, and they don't always work like this, and especially in logical reasoning, they often don't work like this. The idea behind an argument is this. You accept the premises as true. You don't get to quibble with whether or not the premise is true. And then if it is a good argument, accepting the premise as true will lead you to accept the conclusion as true. Because the premise is supposed to be a good reason to believe that the conclusion is true. When an argument is bad, and we're going to talk about criticizing arguments, there's a problem with this. There's a reason why the premise, even if it is true, is not necessarily leading you to the argument. But this stuff contained here, as opposed to what I'm about to talk about right over here in a second, is what the makers of the LSAT care about. The conclusion is the most important part of the passage. It's what the author wants to prove to you. The premise or premises are supposed to convince you that the conclusion is true. So Isaac is asking in the Q&A box, are the premise and reasoning separate? I would say no, in that what I would say is the reasoning is an explanation of how the premises support the conclusion. And so I don't know that they're separate, but I think reasoning is looking at the way the premise gets to the conclusion, but the premise is just a thing itself. So I think they're a little bit distinct, but one is kind of contained in the other. Not everything that you read is part of the argument. A lot of times there is stuff that is neither premise nor conclusion. And it's important to understand that stuff often and then put it to the side, because the makers of the LSAT sometimes are just kind of serving you some context, some information that's important for you to understand so you can orient yourself before you read the argument. But it's not actually part of the argument. So Ahmed asks, are premise and evidence synonymous in this context? Yes, I treat premise and evidence as the same thing. That's what they'll call it in court, is evidence, but premise, evidence. I look at those as the same thing. Sometimes, like I was saying, when it comes to background, it's important. It's context. You need to understand it, or else you can't figure out what the argument is saying. But sometimes the authors of the LSAT are serving you garbage that will slow you down or confuse you or cloud the issue. And the background is not context. In that case, it's an active aim by the makers of the LSAT to distract you. In both of those cases, it's important to understand that it is not actually part of the argument and put it to the side. So I have an example. In this example, there is a conclusion, there is a premise, there is background. And so I'm going to ask you guys to help me dissect this argument. We're going to find the conclusion. We're going to find the premise that supports it. Once we have done that, we will understand that the rest of the stuff that is written here is neither premise nor conclusion. So here's my example. Traffic is terrible today. This is entirely the governor's fault. He cut funding for freeway maintenance by 90%. And I hear there are now potholes in freeways all over the state. So first of all, like I said, the conclusion is the most important part of this argument. So where is the conclusion here? What do you think the author is trying to prove to you? What is the author hoping that you will come out of this with? So I see one answer, traffic is terrible. Now I'm starting to see what I think is the main conclusion of the argument. So I saw a couple of statements, but here is the one that I think is the main conclusion. This is the governor's fault. And this is what we like to prove, right? As human beings, whose fault is this? My life is miserable today. I need someone to blame. And this is actually a common type of conclusion, which is just locating the source of a problem. So I think that is the main conclusion. It doesn't have any conclusion indicator words, which we'll talk about in a little bit as we go forward. But trying to blame the governor, I think, is what the author is trying to prove. Now, where is the support for this? What is the reason that you should believe that it's the governor's fault? And if you can see the relationship between them, you'll start to see how arguments work. Yeah, I see a lot of answers. He cut funding. And I think there's actually two premises. He cut funding by 90%. there are potholes all over the state in freeways. And so you can put those two things together. And if you put those two things together, those are a reason to believe that the governor is to blame for this situation. What you'll notice, and I know some of you gave it some love, but we ignored this guy. Traffic is terrible today. And I think that's background. It is not the conclusion. We're not trying to prove traffic is terrible. The author is kind of sitting in the middle of it. What the author is trying to prove is who is to blame, but you can't talk about who is to blame until you know what it is we're blaming somebody about. So this is a common type of context, which is often background, which is, it's just the topic that we're discussing here. It's the thing we're trying to figure out who is to blame for it. So this is the way I think this argument works. There is a main conclusion. It's this guy right here. There are some premises, some support for that conclusion. And then this is background. It's important context. You would not understand what the argument was saying if you took this out. This is entirely the governor's fault. Well, what is entirely the governor's fault? But again, it is not the conclusion, nor does it support the conclusion. And therefore, it is background. Again, what the makers of the LSAT care about is how this is supposed to support this, whether or not the premises do a good job or a bad job. All right, so that was our first dip into argument analysis. Now let's make a system out of it. So I see someone is asking, are we supposed to accent? And I think what you mean by that is the highlighting that I'm doing. And I would say yes. So when you take the LSAT, and we have this functionality available in our app, if you take the LSATMax course, you will get 3 highlighter colors, yellow, pink, and orange, and you'll also be able to underline. And so I think this is especially important with reading comprehension, and we'll do a couple of, or at least one reading comprehension passage today. We'll see how argumentation works in reading comprehension. But I use those tools to slice and dice arguments so I can see the argument structure. So even in logical reasoning, maybe it's not as important with reading comp because I'm not like having a whole passage to analyze, but I will still do it with logical reasoning because I think it is helpful. All right. Someone is asking, are we supposed to accept this, which I think is this, as the reference to terrible traffic that is incorporated by reference? Yes, that is a very legalistic term, incorporated by reference, but I would say yes, this is referring back to the idea that traffic is terrible today. All right, so whenever you have an argument, and like I was saying, sometimes you will have multiple arguments, you should always do these things. Some questions are just going to ask you to analyze the argument. We're going to talk about being critical of an argument in a little bit, which is an extra step that's added onto this that is very important. But with every argument, you must do this. And we've already done this, and we kind of did it in this order. And for the most part, this is the order I do it in. Identify the main conclusion. I underline that. Identify the premises. I tend to highlight those in yellow. If you'd like, since it is one of the highlighter colors for background, we could highlight that in orange. But this is what I always want to make sure I understand. Where is the premise? Where is the conclusion? What is the background? Let me put it to the side because it's not entirely important. So how do we do that? How do we identify the main conclusion? How do we identify the premises? How do we identify background? Well, the main conclusion is always the thing the author is trying to prove. And so a lot of times you'll hear, well, you know, what is the author trying to prove to you? Or it is the statement that is supported by another statement. That, I think, is a good way to look at it, but there are just common ways that conclusions show up on the LSAT. There are common indicator words that indicate conclusions. Sometimes the makers of the LSAT are telegraphing where the conclusion is. And so I think if you keep these things in mind, they can be helpful for finding the main conclusion of an argument. Easiest and most straightforward is to find conclusion indicator words. These are words where when I say conclusion indicator, what I mean is the thing that comes after them is the conclusion. So when you have the word thus, or therefore, or hence, or so, as a result, how could I have missed this? Ergo. They almost never use ergo, but that's one of my favorite conclusion words. All of these words introduce conclusions. And so you don't have to think about it when you see a word like this. You know what comes after it is a conclusion. But you'll notice I said a conclusion and not the main conclusion. And that is something a little bit different. I think I saw a comment in the chat box about this in our last argument, but some arguments have conclusions that are not the main conclusion of an argument. Instead, those conclusions are what is known as a subsidiary conclusion. And here, very briefly speaking, is how a subsidiary conclusion works. A subsidiary conclusion is a statement that has support. Usually it's supported by a premise. And then that subsidiary conclusion goes on to support another conclusion, usually the main conclusion. And so this is the way that it works in terms of support. We were talking about how you accept the premise is true. It leads you to accept a conclusion is true. Well, if that conclusion is used as a premise, once it is made to support a further conclusion, it may be a conclusion and yet not the main conclusion of the argument. So you have to watch out for that. Sometimes, especially if they're asking you for the main conclusion, so there are main point questions that ask you something like, what is the main point of the argument, or what is the main conclusion? They're likely to be tricky there in that they will give you that conclusion word, but it's not signaling the main conclusion. Instead, it's signaling a subsidiary conclusion. So those are helpful. These words always introduce a conclusion. Just be careful about subsidiary conclusions. There's also just a most commonplace. So I see is a question, is that the same as an intermediate conclusion? Yes. Subsidiary conclusion, intermediate conclusion, same thing. Yeah, so there's also just a common way that arguments are often delivered. So I hear, what is a main point then? That is also the main conclusion of the argument. Right, so there's also kind of a common place that the conclusion often comes. There's just a way that is the kind of easiest to deliver an argument. And it's where the conclusion is the meat in a background premise sandwich. And what I gave you, this example I gave you to begin with, was exactly that. There was some background to start, so that's the top piece of bread. Then the conclusion came after, that was this guy right here. Then and only then did we get the support for it. And this is just a way to make an argument that makes sense, because the way the arguments like this work is, let me explain to you the subject matter we're talking about. Here's my thesis. Now here's why it's right. So I see, are there exceptions to these keywords that identify it? There are not exceptions in that these words are always introducing conclusions. The only exception I can say is that they're not necessarily introducing the main conclusion. All right, so I know I'm kind of jumping back and forth, but this is very commonly how arguments are delivered. Background explains to it educates your listener on the subject matter. Then you get the main conclusion. And after that, you get the support for it. That's not always the case, but if you're struggling to find a conclusion, that's commonly how arguments are structured. And then finally, and I think this is actually the most reliable way to find a conclusion, is by common conclusion type. There are statement types that almost every time you see them, they are not just a conclusion, but they are the main conclusion of the argument. And so this can help you identify, especially where there's a subsidiary conclusion, this can help you identify the main conclusion as opposed to it. And so I'll explain each of these. And I have them listed out here in what I think is about like descending order of how common they are in the LSAT. So by far, I think the most common conclusion is what I would call disputation. And that's just when you're saying someone else is wrong. So it's very common that you'll get an argument that says something like, some people think all dogs have tails, but they're wrong. My dog Buddy doesn't have a tail. Well, in that case, that first statement, some people think all dogs have tails, is the background. Then we are dedicating our entire argument to proving those people wrong. This is the most common conclusion type because, like I was saying, a lot of what you do as a lawyer is attack the arguments of opposing counsel. A lot of what you argue is that someone else is wrong. And so that is a very common conclusion type. Some of these other ones tend to come along with certain subject matter, like a recommendation or the solution to a problem. These very commonly, and I'll talk about it in reading comp, but it's true in logical reasoning too. These very commonly come in legal passages, in social science passages. And a lot of times on the LSAT, authors are trying to solve problems. They're trying to fix issues. And their recommendation, their solution to the problem is probably the main point of the argument. These statements often have the word should or ought, like we should build the airport next to the subway station or something like that. That's probably the main conclusion of that argument. In science passages, an explanation or a hypothesis, which is just really a fancy way of saying an explanation, these are very commonly the main conclusion of an argument. If there's some mystery out there and the author explains to you what is the resolution of that mystery or what's going on with that mystery, that explanation is probably the main point of the passage. A prediction is often the main point of the passage. I know this sounds kind of vague, but an opinion, something is good or bad. These can be value judgments. Something is fair or unfair, just or unjust, righteous or evil, things like that. And sometimes, and this is more common in reading comp, but it does happen in logical reasoning, the answer to a question is often a conclusion. So what I'm doing usually, most of all, is looking for these. If I find one of these guys, I have very likely found the main conclusion of the argument. You must also identify premises. Just like there are indicator words for conclusions, there are indicator words for premises. Because, since, for example, after all, these are all introducing premises. And so when I see one of these, I want to make sure that not only do I know, hey, this is a premise, but also where is the conclusion it supports? Because a premise supports a conclusion. So I see I'm being asked about the words but and unless. But, however, those signal a shift in attitude, which often, although not always, indicate a conclusion. And the type of conclusion they often indicate is this one, disputation. However, those people are wrong. But they don't have to. They are not, strictly speaking, argument indicator words. But, however, it's just they very often introduce a conclusion. The word unless actually has a logical form as part of a conditional statement. So if I said, something like, unless it rains, I'll go to the park, you could actually diagram that and it would look like this. If it does not rain, then I will go to the park. So I would not look at unless as an argument indicator word. I would look at it as a sufficient and necessary diagramming indicator word. All right. So these guys identify premises. I want to just kind of cordon off the word because. However, because it can function in a couple of different ways. If you're dealing with one of those explanation hypothesis conclusions, sometimes they'll say something like, this is because. And since the explanation is the conclusion, this is actually introducing the conclusion. There should be support for it somewhere, support for the idea that this is the right explanation of the mystery. But it can be a little bit confusing. So the word because usually introduces a premise. If I just say A because B, then A is the conclusion that is supported by B, the premise. But when they're trying to offer you an explanation of a phenomenon, when they're trying to solve a mystery, sometimes they're showing you the main conclusion. So I would just watch out for that one. But these other guys, when you see them, what's coming after is a premise. You can just be comfortable with that. Like I said, there are common premise types: an example, a study, an experiment, research. In an argument that someone else is wrong, very often a counterexample is a premise. Finally, identifying background. Background is often important to understand. Sometimes it's not important to understand. Sometimes it's a distraction. And I'll talk about the difference between the two of those. But anything else besides premise and conclusion is background. And again, the makers of the LSAT may want you to understand the background, but it is not, strictly speaking, part of the argument. The argument is the premise and the conclusion and the relationship between them. There are some keywords that indicate the fluff type of background. These words, when you see them, especially in a logical reasoning question, when they say, while blah, 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 all of the stuff in that first clause that comes after while before the comma is a distraction. Or if they say although or even though or something like that. Everything up to the comma is background. So I'm getting asked for an explanation of unless. I'll just do it very briefly because it's a little bit outside of the topic right now. There are two ways to diagram unless. I diagram it this way, which is, to me, unless just means if not. And so to me, it introduces the sufficient, the thing that comes on the left side of the arrow, and then you should negate the sufficient. So that example that I gave, unless it rains, I will go to the park, I would do something like this. Unless means if not. If it does not rain, I will go to the park. Some people do it another way, in that it introduces the necessary, but you negate the sufficient. In that case, you would end up with the contrapositive of this. So unless it rains, I will go to the park. If unless introduces the necessary, it looks like this. Unless it rains, go to the park. No matter what, when you have unless, you're always slashing the sufficient. As long as you're slashing the sufficient, it kind of doesn't matter which term you think it introduces, because you will either end up with this, or you'll end up with its contrapositive. So I think the easiest way to do that is just slash the sufficient. And for the student who asked, you don't have to apologize. The digression, I'm sure, is helpful for other people for whom it is difficult. Right. So these are indicator words for fluff. Watch out for them. There is common background type, and we're going to see it tonight. Again, this is often the stuff that starts out with the stimulus, but the point of view to be disputed. Like when I gave you that argument, some people think all dogs have tails, but they're wrong. That idea, some people think all dogs have tails, is the point of view I'm about to trash. It's not my conclusion. It doesn't support my conclusion, but it's context that's important to understand. The problem to be solved is common background. The phenomenon that we're going to explain with a hypothesis is common background. So when I see those things, their context, it's important to understand, but put it to the side. I see somebody asking about reading comp. We will get there. It's coming. All right, so now we know how to do argument analysis. And what we're going to do is to jump into a few logical reasoning questions. And each of the next few questions has multiple arguments in it. We're going to have to tease out those multiple arguments and figure out what's going on. So this is a main point question. They're asking us which one of the following most accurately expresses the main conclusion drawn in the marine biologist argument. And there's a lot going on here. So I'm getting a question, does the why because analysis ensure you have the conclusion? Well, if the argument is geared toward explaining a phenomenon, then yes, but there should be some support for that explanation. So let me give you an example. They might give you an argument that looks something like, Earth is, I don't know, 20 degrees hotter now than it was a million years ago. And they'll say something like, this is because carbon dioxide has increased in the atmosphere. That would be the main conclusion. That's an explanation of why it's 20 degrees hotter. And then they'll give you some support, like a recent study showed that carbon dioxide in the atmosphere has tripled over that time, and that carbon dioxide has been shown to trap heat in the atmosphere. All of that study is support for the explanation conclusion. So I'm getting the question, should we read the question first or the stimulus first? There are people who are, okay, guys, don't shout out the answer choice. I'm very proud of you, but let's get to it. We have not gotten there yet. You can put it in a private message to me. I don't know if everybody else is seeing the chat box like I am. But if you are, people get angry when you shout out the answer. What I was answering the question is, I personally read the question stem first, but it depends on what your approach is. So for some people, they will read the argument first because reading the question stem first makes them read too narrowly. So if you feel like you're just going to be doing kind of results-oriented reading as you're reading the question stem, then, yeah, and people are still shouting the answer. Please stop shouting the answer. Okay, I see 2 panelists. Okay, I'm sorry, never mind. You can shout it to me. Yes, there you go. Send messages to panelists only. That will be very helpful. So what I was saying, just to round out that conversation, it depends on how you approach things. So I read the question stem first because I feel like it gives me a good way of knowing what's coming at me and finding what's important. But it also can cause you to read narrowly because you're reading to find something. And if you feel like that's something that is not helpful for you, then maybe you should read the stimulus first. So I think it's a matter of style. All right, so let's jump into this. There are multiple arguments here. We're being asked about the marine biologist argument, and not all of the arguments are his or her argument. So marine biologist says scientists have long wondered why the fish that live around coral reefs exhibit such brilliant colors. One suggestion is that coral reefs are colorful, and therefore that colorful fish are camouflaged by them. Many animal species, after all, use camouflage to avoid predators. However, as regards the population around reefs, this suggestion is mistaken. A reef stripped of its fish is quite monochromatic. Most corals, it turns out, are relatively dull browns and greens. I see one of those common main conclusion question types here. And when I see one of those common main conclusion types, not question types, main conclusion types here, and when I see one of those, it's often the main conclusion. So let me just jump back and look at that because I think identifying the main conclusion is important. So look at these: disputation, recommendation, explanation, hypothesis, prediction, opinion, value judgment, answer to a question. This one you can shout out. Do you see any of those here? If so, it is likely the main conclusion of the argument. So I see somebody saying disputation. I see someone else saying disputation. I see lots of people saying disputation. And I see exactly that. And that is very, very, very likely to be the main conclusion of the argument. This suggestion is mistaken. We'll see the word however. And like I said, often that introduces one of these disputation conclusions. Not always, but very often it does. And in this case, it does. The author is disputing someone else's argument. And so often when you see that, even if you have a gigantic stimulus like this, that's the main conclusion. Those 4 words, this suggestion is mistaken, I think is the main conclusion of the argument. But there's a lot going on here. There is a full argument that we have to address. And that full argument the marine biologist gives us is the argument that scientists have long been making. So scientists have long wondered why the fish that live around coral reefs exhibit such brilliant colors. One suggestion is that coral reefs are colorful, and therefore that colorful fish are camouflaged by them. That is a conclusion, but it is not the author's conclusion. This instead is an explanation. So we're saying, why do fish that live around coral reefs have brilliant colors? Here is one explanation of that idea. It's that basically they're trying to camouflage themselves. And they even give us a premise that supports that. Many animal species, after all, use camouflage to avoid predators. After all is a premise word. So we have a whole argument that the author is laying out for us, only to come in and trash it. So I think that's the first argument. It goes from here to here. But, and this is going to become especially important with reading comprehension, we're being asked about the marine biologist's argument. That is the main conclusion of the scientist's argument. And the marine biologist may be a scientist, but the marine biologist is a different party in the passage. Finally, we have to find the premise or premises that support this conclusion. And I think it's this stuff here. A reef stripped of its fish is monochromatic, and most corals, it turns out, are relatively dull browns and greens. In other words, these colorful fish aren't blending in with anything, which makes it seem likely that this explanation is actually the wrong explanation. So this argument, I think, can be broken down like this. You can look at the full argument up top as just very detailed background, because it is not the author's conclusion, nor does it support the author's conclusion. It is an entire argument by itself, but let's put it to the side. The rest of this stimulus is the argument. It's the main conclusion. However, this suggestion is mistaken. And then it's a couple of very good reasons to agree that the suggestion is mistaken. So this is the way I think this argument works. This stuff here is premises that supports this main conclusion. Premise, main conclusion. All of this stuff up here is a whole argument, but it's background to the marine biologist's argument. All right, I think we've done a pretty good job of tearing this one apart. Now we have to find the main conclusion of the argument, and I've seen it shouted out in the chat box already many times, so let's just find it. The right answer that regurgitates it's always more complicated than it needs to be, but that regurgitates that main conclusion is C. The suggestion that the fish living around coral reefs exhibit bright colors because they are camouflaged by the reefs is mistaken. If you were running out of time on this question and you were being asked what the main point of the argument is, and you saw something like the word, "this thing is mistaken," that is just the kind of thing that's likely to be the main conclusion of an argument. So I do think that it's like attractive as an answer choice, just in its understanding of how argumentation works. So I see somebody saying, my issue is that bright colors was not used in the argument, only brilliant. The makers of the LSAT, I call them the kings of the synonym. They say the same thing in a million different ways. And I think sometimes that's kind of the art of the LSAT, is seeing when they are referring to the same thing and seeing when they're not referring to the same thing. But I do think bright and brilliant here are being used interchangeably. All right, let's do one more bit of argument analysis, and then we can get to the fun part, which is argument criticism. So here we're being asked to do something a little bit different. They're picking out a particular piece of the argument and asking us, what role does it play in the argument? So this question is asking us this: the claim that the town's charter, if not restored, will soon deteriorate beyond repair plays which one of the following roles in the librarian's argument? We call these argument structure questions. Some companies call them role questions. But this is where they'll pick out one piece of the stimulus and ask you, how does it function? So again, just like our last question, there are multiple arguments here. And we're going to have to figure out whose argument is whose. I see Janice saying, please don't type the answer. I'm 100% in agreement with Janice. Don't type the answer. We'll do it together. So librarian says, some argue that the preservation grant we received should be used to restore our original copy of the town's charter, since if the charter is not restored, it will soon deteriorate beyond repair. But this document, although sentimentally important, has no scholarly value. Copies are readily available. Since we are a research library and not a museum, the money would be better spent preserving documents that have significant scholarly value. All right, wow. So first of all, let's try to find the argument's main conclusion. So I do actually see one of those common conclusion types we talked about, although I don't think the main conclusion is the meat in a premise background sandwich like last time. So where do you guys think the main conclusion is here? What is the author trying to prove to you or to convince you of? So I see the last sentence, conclusion, money better spent. Yes. And I think this is a recommendation. Like I said, these are very common. You can also look at it as an opinion. One thing is better than another. But the argument is making a recommendation. And when I see a recommendation, like I said, almost always that is the main conclusion of the argument. But that's not what we're being asked about. We're being asked specifically about this claim. If the charter is not restored, it will soon deteriorate beyond repair. I see an indicator word that tells us what kind of statement this is. What is that indicator word? Since. Since introduces a premise. So without even like thinking through how this argument works, this word just tells us straight up it is a premise. That in and of itself would just allow me to get rid of B, because it is not a conclusion, just by the force of that word. So premises always support conclusions. Whose conclusion does it support? Does it support the author's conclusion, or does it support someone else's conclusion? Be careful, it's someone else's conclusion. This does not support the author's conclusion. This statement looks like this. Some argue that the preservation grant we received should be used to restore our original copy of the town's charter, since the way the word since works is that it introduces a premise and the other half of the sentence is the conclusion supported by it. Sometimes it comes late in the sentence, meaning the beginning of the sentence is the conclusion. And this, again, is another recommendation, but it's not the author's recommendation. The author thinks this is a bad recommendation. So I think this argument looks like this. Some, this is the conclusion of some. The author doesn't like their conclusion. The author thinks their conclusion is wrong. But this is a premise that supports the conclusion of some. So now I invite you to look at the answer choices, since we've worked it all out. How does that statement work? If the charter is not restored, it will soon deteriorate beyond repair. Which of these answers accurately characterize how it factors into the argument? I see a bunch of answers and they are the right one. It is a premise in an argument whose conclusion is rejected by the librarian's argument. And that's exactly what's going on here. The author rejects the idea that we should restore the copy. The author says, no, it's a waste of money. So it's a premise, but it is not a premise of the author's argument. It is a premise of the author of some. So I'm getting, why is A wrong, is the question I'm getting asked. It is a claim that the librarian's argument attempts to show it to be false. I don't think that's true. To the extent that the author is trying to show something to be false, it's this statement up here, that we should restore our original copy. The author says, no, that's not true. This statement, if the charter is not restored, it will soon deteriorate beyond repair. The author, the librarian, never says that's not going to happen. Instead, the librarian says, you know what? It's really not that big of a deal. So the author doesn't actually say it's false. Again, to the extent that the author is disputing anything, the author is disputing that conclusion that we should restore it. The author is not disputing the premise supporting it. That's actually an important distinction on the LSAT, is people will dispute a premise, or sometimes people will dispute a conclusion. So I'm getting the question, how would a claim be worded compared to a premise? A claim can be a premise or a conclusion. And a claim can also be background. So I would interpret the word claim kind of as a throwaway. I don't think it has an argument structural role to it. All right, so that's analyzing an argument, which is important, but we must also criticize an argument. The questions we've been doing so far were the types of questions that just ask us, what are the pieces of the argument? How do they fit together? That is important, but in logical reasoning especially, it's actually only part of the game and only a small part of the game. And instead, what is important is criticizing the argument. So this is where lawyers make a lot of money, is in the intellectual combat. And if you're good at intellectual combat, if you can tear down other people's arguments, then you will serve your client's interests better. So all three of these things are the things we learned how to do. Identify the main conclusion, identify the premises, make sure you understand the background. But especially when you're doing some very common question types like errors in reasoning questions, strengthen, weaken questions, necessary, sufficient questions, it's important to know what's wrong with the argument, because you're being asked to do some kind of change to the argument. You're being asked to add a premise to an argument when you're being asked to strengthen or weaken it. So once you have analyzed the argument, you've identified the premise and the conclusion, you have to ask yourself, is the premise a good reason to believe the conclusion is true? The LSAT serves you bad arguments. That's a huge part of it. Logical reasoning, most of the arguments are bad arguments. There's something wrong with them. This is where, even though we're kind of taking a step beyond argument analysis, it's still very important to do that argument analysis stuff, because what we're doing is getting this guy out of the way, the background, and then we're focusing on the relationship between these two things. How do the premises support the conclusion? Do they do a good job or don't they? There are, just like there are different ways to find the main conclusion or a premise, there are different ways to be critical of an argument. One of the great ways is to find one of the 33 common LSAT flaws. So we have a book, the entire text of that book is available to our students once they sign up in our Errors in Reasoning module. And it walks you through 33 ways that arguments fall apart on the LSAT all the time, that the premises turn out to not be a good reason to believe the conclusion is true. If you find one of those LSAT flaws in an Errors in Reasoning question, the right answer choice should accurately describe the flaw. In a strengthen or weaken question, the right answer will either fix the flaw or exploit the flaw. But that's important to all of those question types. Sometimes you won't just straight up find one of those 33 common LSAT flaws, but I think this is a good exercise, and this is a good exercise to think about when people are trying to convince you of things in general. Put yourself in this position. Narrowly focus on the conclusion and ask yourself, okay, what if I was in this situation? In 10 minutes, I have to walk into a courtroom and testify under oath that the conclusion is absolutely true. And if it's not, I'm going to jail for perjury. What evidence would I need? What kind of premises would I want that would convince me, that would reassure me that when I walk into this courtroom and I raise my hand and I take the oath, that I am not saying something that is not true under oath? A lot of times when you think about it that way, it will be clarifying, because you'll think, the reasons they're giving me for this conclusion are just irrelevant. They're just not talking about the right things. And we're actually going to see a question that's doing that in just a moment. But I think this is a good way to think about it, which is a lot of times people will read the premises and they don't really support the conclusion, and they'll think, oh, well, you know, they did a good job with the premises, but they just didn't make it to the conclusion. And that has argumentation backwards. The whole point of putting the premises in there is to serve the conclusion, is to convince you that the conclusion is true. The arguer doesn't care really whether you accept the premises. They only care if you accept the premises, because those premises will lead you to accepting the conclusion. And so focus narrowly on the conclusion. Are we doing a good job of proving this thing or not? And then, like I was talking about, compare premise and conclusion. Is there a distance between them? Are they talking about the right things? Are they talking about the same thing? Sometimes you'll see that they're really not. We actually have a lot to get through, and so I think I'm going to skip this next one because it's going to take us some time to work through. And I just want to do the next one. And then we will talk briefly, before I get to your questions, about tracking arguments and reading comprehension. So this question is an Errors in Reasoning question. They're asking us what is wrong with the argument. The argument is vulnerable to criticism. So the argument says this: consumer, the latest Connerly report suggests that oxen-fry prepackaged meals are virtually devoid of nutritional value. But the Connerly report is commissioned by Danto Foods, oxen-fry's largest corporate rival, and early drafts of the report are submitted for approval to Danto Foods' Public Relations Department. Because of the obvious bias of this report, it is clear that oxen-fry's prepackaged meals really are nutritious. All right, what is our main conclusion here? What is the author trying to prove to you? This one you can shout out, just not the answers. Yeah, the meals are nutritious. And we can actually tell this because of this structural indicator word. The word because introduces this premise. The report is biased. The other half of the sentence is the main conclusion. So let's put this, everything that they talk about before that last statement, or the last half of the statement, let's put it to the side. If you had to testify under oath in 10 minutes that Oxenfry's prepackaged meals really are nutritious, what would you want to know about them? What information would you need? Just the quick details before you walk into the courtroom and state under oath that Oxenfry prepackaged meals are nutritious. What do you want to know about them? I see ingredients. I see what are the vitamins. I see nutritional facts. What is the nutritional value? I see evidence. Yeah, what sugar is in there? Is it processed? Let me ask you, how much of that did you get as support for this conclusion? Is it organic? Nothing. Nothing. So if you were about to walk into a court, would you say, I need to testify right now that these things are nutritious. So what I need to know is, do these people have a competitor and are they biased? Who cares about how biased this report is? It is irrelevant 100% to whether or not this food is nutritious. That is a factual statement about how the world works. There are these products out there in the world. Nutritious has a definition in that it's like unlikely to make you sick or to make you unhealthy in some other way. The idea that there is bias is just irrelevant to that conclusion. So if you can see that, if you can see that the premises are just talking about the wrong stupid thing, then the answer choice is likely to get at that. So look at the answers, and now that we have really thought about what this argument should be doing, let's find the answer. So I see A. A is the correct answer, but I also see the question before it runs by, is bias always irrelevant? Here is a conclusion that I think you could support using this bias. If the conclusion of this argument is, so if this argument boiled down to this, because of the bias of this report, you should ignore its conclusions. If that was a recommendation being made because of the bias, then I think the bias would be relevant. Because I think bias gives us a good reason not to listen to Danto Foods. Sure, but it does not support a conclusion about the factual world that this food is nutritious. Bias is irrelevant to whether or not this food is nutritious. It is not necessarily irrelevant to whether or not you should listen to Danto Foods. I think in that case, bias is relevant and you should just tune out Danto Foods. So I'm getting, Victoria's asking, I think it depends on the conclusion. Yes, it depends on what you're trying to support. Here, we're just not supporting a conclusion that would be supported by bias. The right answer that just gets at the idea that we are not looking at the right evidence is this guy. It treats evidence that there is an apparent bias as evidence that the Connerly report's claims are false. Remember, the Connerly report's claim is that the prepackaged meals are devoid of nutrition. So Nardine is asking, but what if they lied in the report because of the bias? Then I think it would still be a problem for somebody who wanted to rely on the Connerly report. But again, it is not good support for an affirmative conclusion that the meals are nutritious. And so this is where I think people start to kind of wander away from what's going on. And that's why I talk about being very narrowly focused on the conclusion. That's what the author cares about. It's what the author wants to convince you of. To convince you of that particular point, whether they're lying, whether they're biased, it's just the wrong evidence to present. Yes, all right. So just before I start taking your other questions to the extent that we have them, let's talk about argument analysis and reading comprehension. Should D be a good, so Patricia's asking, should D be a good answer too? D says fails to provide evidence that Danto Foods prepackaged meals are not more nutritious than Oxenfry's are. So again, and here's another way to think about just how narrow this conclusion is. The conclusion is that Oxenfry's prepackaged meals are nutritious. If Danto Foods are better, if Danto Foods are worse, that might show that Danto Foods is full of a bunch of hypocrites. But again, that kind of information is irrelevant to whether or not Oxenfry's meals are nutritious. Maybe Danto is more nutritious and they're still both garbage because Oxenfry is terrible. Maybe Danto is less nutritious and Oxenfry is better. The conclusion is very narrowly one company, Oxenfry, is their meal nutritious or not? Danto Foods may be hypocritical, but that's irrelevant to that conclusion. And failing to provide irrelevant evidence is not a flaw. That's how I'll say that. All right. So we have done 95% of what you do in analyzing arguments and reading comp. We already know how it works. And in fact, we've already seen logical reasoning questions that have multiple arguments in them. And so we've already actually done the rest of the stuff that we're going to talk about here. But in a reading comprehension passage, there are almost always multiple arguments. Even in the smaller paired passages, where you have passage A and passage B, a lot of times there are multiple arguments being made in those passages. So we've already done all of that stuff, find and analyze all the arguments. We know how to do that. The one thing that's important is that the author often chimes in and decides which argument is right and which argument is wrong. Sometimes they do that in logical reasoning too, and it's still important. But the way to think about reading comp is this. You are being asked to read something that is not about the law usually, but it's still structured the way that judicial opinions are structured. So in law school, and when you're a lawyer, you will spend the rest of your career as a lawyer reading judicial opinions. And that's where the judge writes out the arguments of plaintiff and defendant on a particular issue, critiques those arguments, and then decides who is right and who is wrong, who wins and who loses. And so it's important to note that the author gets to decide out of all the arguments that are being made, which one wins. And when you are asked, what is the main point in a reading comp passage? If the author decides one of the points of view, one of the main conclusions is correct, then the author's conclusion is the main point of that argument. So there's not really much else that we're doing. It's just one extra step added on top of that argument analysis. So I've got some paired passages here. We're going to read the first one. We probably won't spend time reading the second one. But this first one has multiple arguments in it. And so we're going to do our argument analysis on those multiple arguments. All right, I'm going to turn this up. I hope it doesn't make you sick or ruin your aspect ratio, but I think it'll just make it easier for us to read this passage. All right, passage A, some legal theorists reject the notion that judges must believe what they say in their opinions. They argue that an emphasis on the need for honesty in judicial decision-making ignores the myriad institutional considerations that judges must continuously balance in performing the prudential functions assigned to them. To argue for rigid adherence to a norm of sincerity, they say, is naive, foolhardy, even dangerously utopian. So I do think there is a conclusion here. We have a party in the passage. It's not the author, it's some legal theorists. So what is the conclusion of some legal theorists? And I'll make it easy. I think they have a recommendation. It's a little bit hard to see because they say they reject the notion. But basically, the conclusion is this. Whoops. If they reject the notion that judges must believe what they say in their opinions, this is a disputation. And so what I'm saying, or what some theorists say, what their main conclusion is this. You can write it out. Judges don't need to believe what they say in their opinions. So this is the rejection of an idea. Some people think judges must believe what they say in their opinions, but some legal theorists think, no, that's not the case. There is support for this. I think it's kind of bad support, And the author, and this is very common in a reading comp passage, the author is likely to give you, or very often gives you, kind of a cruddy argument and then tears it apart. And so here, I think there are a few premises that are supposed to support this idea. And it's this: forcing judges to believe what they say are ignoring these institutional considerations. And here is where I think they're getting into attitude more than premises, but this is some support for this idea that adherence to sincerity is naive, foolhardy, dangerously utopian. So the idea that it's dangerously utopian is supposed to support the idea that we shouldn't hold judges to this standard. We shouldn't make them believe what they say or require them to believe what they say in their opinions. So there is a whole argument here. There's a conclusion. There's a couple of premises about it. Very commonly, this is especially true in full passages. When you get a point of view in the first paragraph, it is very likely that the author is going to trash that point of view. And so to trash this point of view, I would think the author would come in, and it's actually a little bit different. But what I would be anticipating with a passage like this is that the author is going to come in and say, well, actually, judges should believe what they say, because disputing people is very common. So let's read this next paragraph, and let's see if we can get the author's argument and see where this passage is going. So there are two ways of defending the principle of judicial sincerity. The first is to marshal prudential reasons that support the principle. If it can be shown that following a general rule favoring sincerity produces the most prudential outcomes, whatever those happen to be, then the rule is justified. Accordingly, proponents of greater candor in the courts have argued, for example, that transparent decision-making provides better guidance to lower courts and litigants, or that it strengthens the legitimacy of the courts. So this passage, I think, is a little bit different, or at least goes in a little bit different of a direction than I would expect, in that instead of just directly disputing the first conclusion, the author kind of takes it as read that judges should believe what they say. And instead, the author's not saying, I'm going to make the argument that judges should believe what they say. Instead, the author is saying, there are a couple of different ways to make that argument. And so what's weird is that the author, instead of strictly disputing the legal theorists, the author is about to explore a couple of different ways to dispute those legal theorists. How can I defend the idea that judges should believe what they say? Well, there's one way, and I think that way, that possible recommendation is a conclusion. So when they say there are two ways of defending the principle of judicial sincerity, then they give us the first one. And I think this is a recommendation that some might make, although I don't know if the author is endorsing this conclusion yet. Let's define prudential, because they keep talking about it, and this is why I think is unfair about the LSAT, especially with legal passages, is a lot of times they expect you to understand concepts that are bandied about a lot in law school, but that you don't learn until you go to law school. So prudential reasons, often you'll hear about courts doing things or making decisions for prudential reasons. And those reasons are different than substantive reasons. So a substantive reason is when I send the defendant away for 25 to life because the prosecution proved its case. And they proved that the defendant committed the crime. Prudential reasons are when courts do things in order to make sure that courts continue to be seen as legitimate by the public and by the government and things like that. So it's prudential reasons are where the court is kind of protecting its own authority, is protecting itself. And you'll hear a lot about that. So one of the biggest prudential things that courts do is the jury system. So we actually hand off convictions to juries so that people don't get mad at the courts for either convicting somebody who should not have been convicted or not convicting somebody who should have been convicted. So that is a prudential reason. So I see lowering a settlement amount. I mean, I would have to know the facts around it, but I don't know. But these are reasons where basically a prudential reason is where the court is preserving its authority and legitimacy. And so this is the first way, is to argue that if we want to make sure that courts are, treated with the respect and the authority that they deserve, we have to make sure that judges are telling the truth. So that's one way to argue that judges should tell the truth. That's one set of reasons. And then we get examples that support that idea. And examples are premises. So transparent decision-making provides better guidance to lower courts and litigants. It strengthens the institutional legitimacy of the court. These are all reasons why you might want to argue for judicial sincerity on the basis of prudential reasons. So this is another paragraph that has, I think, a full argument in it. One recommendation for how to defend judicial sincerity is to marshal these prudential arguments. Well, the courts will be better off, people will trust them, they'll have more authority if judges are honest and we know they're honest. Makes sense, seems reasonable, but I don't know yet if the author has endorsed that conclusion. So let's look at the last paragraph. The problem with a prudential defense of judicial candor is that it fails to acknowledge the normative force behind the idea that judges should not lie or deliberately mislead in their opinions. In our ordinary moral thinking, duties of truth-telling are not justified merely when they produce good outcomes. Rather, the duty to speak truthfully and openly is an independent constraint on our actions. This suggests a second way to defend the principle of judicial sincerity, namely by appealing to moral principles rather than prudential considerations. So here, what the author is doing, after presenting that argument that here's one good way to argue that judges should believe what they say, is to attack that idea. There's a problem with it. You're not acknowledging that, look, lying is wrong. And the fact that lying is wrong is a better way to defend the judicial sincerity. So I think when it says this suggests a second way to defend the principle, this is the author's conclusion after declining to endorse the last argument, which is the better way to defend judicial sincerity is to say that judges have a moral obligation to be honest. And this is the support for it. The duty to speak truthfully is an openly and independent constraint on our actions. The fact that it is suggesting something, I think, is the makers of the LSAT telling you that's a premise that supports this conclusion, this better support. So there were, I think, 3 arguments in this passage. The last one is the author's argument, because the author takes down those first 2 arguments and then finally settles on this last argument. So if I were to be asked what is the main point of this passage, this statement, a second way of defending the principle of judicial sincerity is by appealing to moral principles. I think that's the main conclusion of the passage. That's the best way to defend judicial sincerity. Unfortunately, we don't have time to get to the next passage or the questions, but picking apart a passage like this, I think, is very helpful and is important. All right. So I'm going to take, and I see there are some questions building up in the Q&A box. I'll take your questions in a moment. But let me just tell you a little bit about LSATMax. We have a couple of different packages. All of them come with payment plans. We know that studying for the LSAT is a big investment of time and resources, but it does pay off in spades by getting you into the school that you want to go to. It can often reduce, or in some cases, eliminate tuition if you get a good enough LSAT score. So it is very much worth it to invest in your LSAT score. We come at the LSAT, I think, a little bit differently than most other companies, and I'd like to just tell you what sets us apart, and then I will be happy to take your questions. What I think a lot of people have learned recently about studying for the LSAT is something we've known for a long time, which is that studying for the LSAT at home by yourself is difficult and demoralizing. We have been a distance learning company since our founding, and we have been addressing that situation since our founding. And the way we come about it is to do our best to make studying for the LSAT in a community, to make LSATMax a community of people studying online for the LSAT together. And we come about it in a couple of different ways. First is, when you sign up for LSATMax, you're going to tell us which exam you're studying for, and we will give you a calendar that's going to lead you through the course, which is more than 100 hours of lesson videos. All of our lessons have homework appended to them. There are lots of flashcards and drills on a lot of the videos. Each of those videos and the homework, each question has a message board appended to it. If you're struggling with a concept or a question, you can ask about it. One of our 99th percentile instructors will answer you. Students also collaborate on questions on these message boards. They're heavily trafficked, so it's a great way to collaborate on the questions as well. You get access to all 90 prep tests in the history of the exam. That's more practice than you could ever want. A couple of other things, we have weekly office hours, which is where one of our 99th percentile instructors will lead you through a common question type or concept. Usually in the week or two leading up to the exam, we have office hours every day. We have personalized support as long as you're with us. If you're struggling, reach out by phone or email. We'll do our best to get you a solution to your issue. Our interface looks exactly like the test day interface. You don't want to learn what it's like to take the exam on the day of the exam, so you can get lots of practice with that. We also track your performance, whether you're taking a full practice exam or just doing a few questions. That's especially important toward the end of the course when you're cataloging your strengths and weaknesses so you can study efficiently and effectively. All of these packages come with a free hour of private tutoring. And these two packages on the right here come with a higher score guarantee, meaning if you do not do better on test day than you did on your first practice exam, send us your score. We will give you your money back. No questions asked. All right, that is my sales pitch. I hope that it was effective for some of you, but now I will be happy to take your questions. So let's see. Let me go over to the Q&A questions first. Let's see. I think I answered these. I think this was getting answered in the chat box, but does anyone know if there will be an LSAT after April 2021 for sure? Thank you. There will definitely be a May or a June LSAT. There's always usually at least a June LSAT. I think they are not announcing it yet because they don't know when they're going to be offering regular in-person LSATs. So I would imagine they would announce it soon. They may not announce whether or not it's going to be an lsat-flex. Sometimes they announce an LSAT and then announce that it will be a flex later, an at-home exam. But it should be announced very soon because we're getting to the end of February and they should have it up soon. Let's see. So Bridget asks, does a subsidiary conclusion always support the main conclusion? It is possible that it supports another subsidiary conclusion. So you could have, an argument could have 10 or 20 or 50 or 90 or 7,000 subsidiary conclusions if you wanted it to. Usually it supports the main conclusion, but it is supporting a conclusion. So it's either supporting the main conclusion or another subsidiary conclusion. Does LSATMax provide support, help with the application process, like editing personal statement or your CV? Yes, we do that. If you want to sign up and get help from a tutor, lots of our tutors, I think, are experienced with that stuff. So we do help with that. Let's see. Trying to keep an eye on the chat box as well. Okay. Let's see, is there typically a July, August, and September LSAT? There's usually a September. There may be a July. It used to be when I started teaching the LSAT that they gave it 4 times a year, the same time every year. Since then, they've stepped it up and they give like 6 or 7 times a year and they kind of change it around. So I don't know, but I do know somewhere in that range, there will be at least 1, if not 2 LSATs, probably a July and a September. I don't know that I've ever actually heard of an August LSAT. People just don't do stuff in August. Let's see. I only have problems for 3 types of logical reasoning questions. Do you guys assist in that or a different package for that? Well, what I would say is that you can use a tutoring package for any issues that you want to work through. So if you have 3 types of logical reasoning questions that you want to work with a tutor, then you can certainly focus your sessions on those 3 types of questions. I hope that answers the question. I'm getting this question. I wish I had time to answer this. What is the strategy for keeping within the allotted time? There is a different strategy for each of these sections of the exam, and it's a very long conversation about each one of them because I do think it's important to be managing your time. What I will say briefly is that the conversation that I have about managing your time on all of the sections kind of boils down to this. You want to get good at skipping around in order to do the questions or passages or games that you're likely to get correct in a short amount of time before you do the other stuff. So prioritize the stuff that you can do quickly and accurately before you do the stuff that's going to take a long time. And you should prioritize that stuff before the stuff that you are likely to get wrong no matter how much time you put into it. It's difficult to like skip around like that because they don't just tell you like how difficult a question is, but there are methods for figuring that out. But unfortunately, we don't have time to go through all of that at this point. Oh gosh, I don't know the answer to this question. What are the odds that they will go back to in-person LSAT in 2021? I mean, I think the odds are good by maybe fall. Before then, I mean, I would be really surprised if anything before fall is in person. All right. So I know it is dependent on the person, but when do you recommend realistically starting studying? 2 months out to 6 months out? The calendar that we usually give our students starts about 4 months out from the exam, but I would look at it this way, which is you are going to spend a minimum of 180 hours, and I would really probably just round it up to 200 hours studying for the LSAT. So the question is, given the amount of time you have per week, how many hours, how many weeks is it going to take you to accomplish that? So if it takes 200 hours to study for the LSAT, you can put in 10 hours a week. That's going to take you 20 weeks. If you can put in 20 hours a week, it's going to take you 10 weeks. So I think that kind of back of the envelope math can help you decide, given your needs and the way that your life is organized, how early you need to start. This question is not for me, but I will put it out there. I saw somebody was forming a study group in the chat. Jenny, what is your study group address? Jenny, if you want to type that into the chat box. I don't know if you've already answered that. All right, let's see. So Megan asks, I am following the calendar, but getting stuck on some of the sections or modules. Do you think it is okay to stay on a section for a couple of days, even if that means I'm getting behind on my calendar? I would try to minimize that. I mean, if there is a concept that you just feel like you do not get, that's one thing. But if you're not seeing a lot of accuracy, but you kind of get the concept, then I would not stop and spend several days on it, because much of what, so when I told you about like 200 hours studying for the LSAT, the last half of that is after the course is over and you're doing practice and review. And a lot of that was, so a lot of practice and review time is identifying your weaknesses and going back and looking at the materials associated with those weaknesses and doing practice on them. So I don't think you should get stuck on them. If there's a concept you do not understand, try to understand the concept, but you will come back to it. All right, I know the chat box has been going by and I know I'm missing it, so let me look back at it. Oh, so I see, I hope I'm pronouncing this right. Safia says, I watched your video on timing strategies. It was helpful. I'm glad it was helpful for you. Yeah, I do believe in our, I think in our office hours modules, you can find some timing stuff in there, including stuff that I've done. So Tristam is asking, I move at a very deliberate pace on coursework. Is that all right? I do think a deliberate pace is fine. What you should have in front of you, however, is a date several weeks at least before your exam where you're done with the course and you're doing practice and review. So a deliberate pace is fine, but ultimately there has to be, I think, a significant amount of time after you're done with the course to really work on your weaknesses and also tailoring the strategies in the course to your personal needs. All right. All right, Janice says, I listen to the podcast as I'm running errands. Well, I hope it's helpful. Thank you to you and the lady who is also on the podcast. Janice, I will tell the lady that you appreciate her. She will appreciate that. All right, let's see. I'm just going to put this up here. So this, I guess, is where the lsac.org/update-coronavirus and LSAT-lsat-flex, that talks about their response to the coronavirus. But again, I have not heard that they're doing in-person LSATs yet. All right, let's see. What do you discuss in your podcast relating to LSAT and application? Well, I mean, a lot. We've done a whole podcast on the application process. You know, we break down different LSAT concepts. I think we're up to about 35 episodes. So I would recommend, you know, just scroll through the episode list, and each episode has its own theme. Sometimes we kind of jump out of the LSAT law school area in order to talk to attorneys about and law professors. So there's a lot going on there. So where is the podcast? You can get it at Apple Podcasts. You can get it on Stitcher. You can get it on Spotify, all of those places. And there is the link for it again. All right. So I hope I answered that question. I think I kind of didn't. So Heidi asks, what are the odds that someone can do well on the LSAT without practicing? I met someone who said they never studied for it and got a 165. The odds of that are not great. And the odds are explicit because a 175 is, I think, like about a 90th percentile score. And so what that means is about 10% of people get that score or above. And the vast majority of those people studied very hard for that exam. There are things that prepare you for the LSAT. Like I was a philosophy major and I was really into symbolic logic and took all of the symbolic logic classes I could get. So I started out with, and this may make some of you mad, my first practice exam score was a 163. But that was because I had been doing this stuff for a while, with the exception of logic games. I had to learn logic games, but the other two sections of the exam I'd basically been doing before. It depends on how your brain works. The LSAT is not a test of subject matter for the most part. So I do think it's more possible that people are just adept at it and somebody can just take it cold and do well than somebody like taking the MCAT cold and doing well or something like that. But the vast majority of people who get a 165 or above put a lot of work into it. Let's see. How do you recommend studying in the last few weeks or month before the exam? So I think once you're done with the initial, like working through the course, then you're in the practice and review phase. And the practice and review phase has two parts to it, very broadly speaking. And the more you get toward test day, the less one of those parts should be part of it, and the more the other part should take over. So what I mean is this: once you're done with the course, you should be, during the course, you should be cataloging your weaknesses, the things that you struggle with. And then as you are doing that practice and review phase, you're doing timed practice on general sets. That might be full practice exams or full sections. But then you're also doing untimed practice on your weaknesses. And that includes reviewing the materials associated with those weaknesses, and then doing untimed practice on them. So ideally, the closer you get to test day, the less weaknesses you have, the fewer weaknesses you have, and the more it will just be timed practice. But I think it starts out a lot of review and a little bit less timed practice. And then the closer you get to test day, the more you're just drilling on timed practice. Let's see. So do you discuss IRAC in any of the courses? So we actually did a Read Like a Lawyer presentation, and I believe the video is available in the office hours part of the LSATMax course, where we do talk about IRAC. IRAC is a little bit useful sometimes in reading comprehension, but otherwise IRAC is not, I think, terribly useful in the LSAT. So it is a way to look at things, but for the most part, like in logic games, it's irrelevant. And even in reading comp, the arguments are so small that you're not going to do a full IRAC on them anyway. For those of you who don't know what we're talking about, IRAC stands for Issue, Rule, Application, Conclusion, or sometimes Issue, Rule, Analysis, Conclusion. And it's a way you break down the arguments in a judicial opinion in law school readings. Again, it can be helpful in reading comp. Let's see. Oops. So like symbolic logic and philosophy courses, what else outside of the LSAT content do you believe is helpful for testing? I heard strategy games like chess. Do you concur? And I'm seeing the question about The Economist in the chat box, and so I'll answer these questions together because that is part of this question. We recommend, and in fact, well, I don't know if we still give away a subscription, but we recommend that students, in order to prepare themselves for reading comprehension passages, read things like The Economist. And The Economist delivers arguments on difficult subjects worded in a way that is difficult like the LSAT is worded. And so I do think it's helpful if you can start to learn how to process and understand the arguments being made there, then I do think it is helpful for reading comprehension. As far as things like for logic games, strategy games like chess, I mean, yes, in that every strategy game like chess is in a way a logic game, and that there are a number of permutations, and they're kind of just trying to get you to figure out what permutations are currently available, giving a set of rules. The one that I think is kind of like actually gives you a little bit of practice that's relevant for the LSAT is Sudoku, because a lot of what you're doing with Sudoku is what we would call restrictions, where you're figuring out what cannot go in a particular slot. A lot of Sudoku is figuring out what cannot go in a particular square. So that one is probably the most on topic. But when people ask me, what can I do besides the LSAT to study for the LSAT? My answer is the one that they don't like, which is that the best way to study for the LSAT is to do LSAT questions. So I wish there was like fun stuff that was not the LSAT that was just as good as doing the LSAT. But I think for the most part, just grinding away at the content and the questions is what's important. Let's see. Okay, this question I want to take because this is going around. I've heard that it is easier to score higher on the flex exam. Is that true? I just took a diagnostic on LSATMax, but I'm not sure if I'm converting my score correctly because I'm not getting an overall score, just a breakdown of sections. First of all, let me take is the flex easier? That is, I think, more or less impossible because of the way the LSAT is scored. The LSAT is scored on a curve. And so if an LSAT flex was easier than another LSAT, then they would just tighten the curve. And what that would mean is you would have to get more questions correct to get the same score. This rumor stems from this, which is the number of people applying with 170 plus scores this year has skyrocketed. And it is a larger proportion, although still a very small proportion, it is a larger proportion of people applying for law schools. The reason that there are more 170 pluses applying is not that there are more 170 pluses being handed out currently. It's that there are a lot of people who are very smart people and got over a 170 on the LSAT, but people like that are good at a lot of stuff. And so before the pandemic hit, a lot of those people took the LSAT and they didn't go to law school. And now they're saying, well, you know, I lost my job or I lost what I was doing, and now I'm going to take this 170 LSAT score or 170 plus and use it somewhere. So yes, more people are applying with 170s. That does not mean it has gotten easier to get a 170. It's just people who have them in their back pocket are now using them. As far as the score conversion, the only accurate one, or the only one that is like definitely accurate to the way the makers of the LSAT score it, is that I think you can take, but I'm not sure if you can actually score it. I think you can take the May 2020 LSAT, which was an lsat-flex, on LawHub, so lawhub.lsac.com. You can take that exam, and that was a real flex exam. So we have taken all of the exams in the history of the LSAT, and we offer them as flexes. So you can take an exam from 10 years ago as a flex exam. And the difference between a flex and a regular LSAT is that on a regular LSAT, there are 5 sections, 4 of which are scored. On an LSAT flex, there are only 3 sections, and all of them are scored. And so the way that we have changed the scoring, so we'll still give you a score if you take an LSAT flex, but the way that we have done it is that the percentage of questions that would get you a score on the full LSAT, we just take that same percentage of questions and give you that score on an LSAT flex. So for instance, if you took prep test 62, and in a normal, the way the score works on prep test 62 is that you can miss 10% of questions and get a 170. Well, that's 10% of about 100 questions, those 4 scored sections. So that means you can miss about 10 of those questions. The way that we do it is if you take it in flex format to get that 170, you would still have to get 90% of the questions right. In other words, you could miss about 7 or 8 instead of missing 10. But that's just our estimation of how the scores should be done. The makers of the LSAT have not been clear about how they're scoring things since the format of the exam has changed a little bit. What about brain training apps? I don't know. I have not tried those. I don't know how well they work. Maybe? I have no answer for that question. Let's see. We are about to run out of time, but let me just answer 1 or 2 more before we go. Do you think ABA and schools are moving toward a more hybrid education or all online curriculum? Well, I know the ABA, at least before the coronavirus pandemic, kind of looked down upon online law school education. I don't know if that's going to change. Obviously, if remote learning becomes necessary for years on end, then the ABA may change its the way that it does things. But I would expect, well, I guess what I would say is this. I would expect because of the pandemic, the ABA will become more flexible and that some schools may move to full online programs or, at least have a full online option rather than, just having to have an in-person class. But that said, and maybe this is because I went to law school before the pandemic and I just can't think outside of the box, but especially your first year of law school is very collaborative. You're in a section with all of the same students. You take the same courses as a tight-knit group of 10 or 12 people. And I think it's very hard. I've talked to some students who are doing their 1L year now. It's really hard to do that year of law school online because you're still studying in sections, but it's all, Zoom conferences. So I think law school probably more than something like med school you could do online, but I still don't think it's necessarily ideal. And I would imagine that the ABA is not just going to sign off willy-nilly on online programs. They might become a little more lenient about allowing ABA accredited schools to do it, but probably not a lot. All right. So let me answer 1 more question, and then I think we will be done. So, whoops, I meant to answer that live. That's not what I meant to answer. What am I doing here? Yeah, so I see here Syracuse Law and NYC as a fully online JD program. Let me answer 1 last question. So this one is on a different topic, and then I'll let you guys know. Go. How can we best prepare for the LSAT writing section? So the LSAT writing section is not scored. Your answer is sent along to the schools that you apply to without comment. It is important in that I think if a law school is thinking about admitting you, they will definitely read your writing sample. We actually have a section specifically on the writing sample in the LSATMax course. It's actually part of our reading comp course. even though it's a different part of the exam. But it's an argumentative essay. And I think what's important is to have an understanding of how it works, which is you are deciding between two options. You're arguing for one option and against the other. They give you some criteria that your arguments must meet. And as long as you are following the instructions, that you're arguing that your option meets the criteria better than the other option, then as long as you're, organizing it in a reasonable way, that kind of like standard 5-paragraph essay, I think you should be fine. I did an office hours, or I did a presentation on that. That's available in our office hours as well. So if you want to have a look at that, you can do that. Take it seriously, but it is less important than the other pieces of your LSAT score. All right. So I think that's about the time that we have. So I'm going to have to let you all go. I hope that this was useful for all of you. I hope that I will see some of you in the LSATMax universe sometime soon. But regardless of whether or not I do, I wish you the best of luck in your undergraduate careers, on the LSAT, on law school. So please stay safe and stay healthy. You are the next generation of lawyers, and we need a great generation of ethical lawyers. Take care. Be well.